Now we are going to start the last session of today, Session 4. In this session, we will discuss cross-border issues in IP infringement. And the session's moderator is Tae Park, presiding judge of Seoul Central District Court of Korea. Please welcome him with a big round of applause. Good afternoon, everyone. As introduced, I'm Park Tae-il. Now we are going to start the last session of today. In this session, we are going to discuss cross-border issues in IP infringement, and we will share insight of the world's best experts in this field. I'm very excited to moderate this session. We have many attendees joining us via online, and we also have attendees who are here in the room. So, as I said, we will share insight of world experts. Let me introduce them to you. We have Judge of a Federal Court of Justice in Germany, Klaus Bacher, with us.
한 변호사님 혹시 네, 그리고 현장에서 함께 해주신 중국의 링우한 변호사님이십니다.
Judge Ling-Woo-han with us.
네, 그리고 세 번째 연사분을 소개드리겠습니다. 한국 특허법원의 정희영 판사님이십니다.
Judge Hee-young Jung with us.
네, 그리고 동영상으로 함께 해주시는 미국 연방 제3항소법원의 조던 판사님이십니다. 앞 세션에서도 함께 하셨습니다.
Jordan, who joined us in previous session, will join them.
드미트리 카시테트 교수님
Professor Dmitry
여러분들께
Kashtat
상세한 정보를 주실
will also
예정이십니다.
join us
그리고 한국의
virtually.
김광남
He
특허법원
will
판사님이십니다.
provide us with more details in this field. And we also have Kwang-nam Kim, a judge of Patent
끝으로
Court of Korea,
일본에서 영상으로
with us.
함께 해주시는
And lastly,
지제고제 구마가이 판사님이십니다.
Judge Kumagai will join us virtually, especially via video.
4세션은 세 가지 큰
In this
주제를
session, we
다루려고
will
합니다. 첫
discuss
번째는
three big topics.
국경을 초월하는 특허 침해 문제를
First topic is
속지주와의 관련해서
cross-border issues in
일반론으로
IP
검토를
infringement.
해보려고 합니다.
Here, we will
두
focus
번째는
on
그
territoriality.
가운데서도
Secondly,
복수 주체 관여에 의해서
we will
일어나는
also
경우를
discuss
특별히 더
IP
질문드려서
infringement
살펴보려고 합니다.
involving
세
multiple
번째는 결국
actors.
권리적
Lastly,
구제를 어떻게 할 것인지와
we will discuss
관련해서
how we are going to
주로
provide
손해상정의
remedies.
문제를
Here we will
구체적인
focus on
사례에 대한
damages,
설명과
and we will
함께
share specific
다뤄보려고 하고
cases of
있습니다.
each country.
본격적인 세션을 시작하기에 앞서서
Before we start the
한 가지
session,
드리고 싶은 말씀이
I'd like
있습니다.
to
오늘 함께
share with
해주시는
you one
연사님들께서는 이미
The
사전에 모든
panelists
질문에 대해서
who joined us today,
대단히 전문적이고도 충실한 답변을
they have
서면으로
provided
보내오셨습니다.
us
오늘
answers,
받으신
very
레퍼런스북에 이
specific
내용이
answers
모두
based on their
소중하게 담겨
expertise
있습니다.
for the questions we asked
여러분
them.
모두의 시간
And all the
상의
answers were
편을
included in
위해서
the
오늘 이
reference
자리에서는
book.
부득이
For the
그
interest
내용
of
중에
time,
매우 핵심적인 답변만
the highlight of the
부탁드리고
answers
싶습니다. 그리고
should
부득이
be
일부
shared.
질문은 순서를 바꾸거나 생략하는 상황이 발생할 수도
For some
있겠습니다.
reasons, we
이
may
점에
have to
대해서는
change the order
연사분들이나
of
또 여러분들께 미리 양해를
panelists to
부탁드립니다.
answer the questions.
자,
So I'd
그러면
like to
시작하는
ask you to
질문으로
understand,
첫
for the
번째
convenience of
질문
the
두 가지를 모아서 한꺼번에
conference.
질문을
So let me
드리도록
first
하겠습니다.
ask the
첫
first
번째
two
드릴 질문
questions.
두 가지는
The first two
특허권의
questions
속지주의
are
원칙과 관련해서 국경을 초월하는 특허 침해를 판단한 사례 또는
please give an
각국의
outline of
해당
any
법령을
incident or judicial
설명해 달라는
precedents on
취지입니다.
patent rights
이
related
부분에
to
대해서
territorial
먼저
principle that have been
독일의 바허
debated in your
판사님께
country. I'd like to
부탁드리겠습니다.
ask Judge Bach to answer the question first.
Thank you very much for giving me the floor once again. So my first session was 2:30 German time. Now it's 8:30 in Germany. I feel much better, and I can imagine how my colleagues in the US feel right now, because it's the same time, I think, as in my first session. Now, we have one recent case at the Federal Court of Justice dealing with this problem. It was about a manufacturer who was in Italy and who manufactured repair kits for tires. And he supplied these kits not to Germany, but to a car manufacturer in Italy. But nevertheless, he was sued in Germany for infringing a German patent, although he only acted in Italy, because some of these repair kits which he had supplied to this car manufacturer were sold in Germany eventually. And the Court of Justice decided the Italian supplier, although only acting in Italy, can be held responsible for this patent infringement in Germany for a contributory act if either he knew that his goods would be passed on to Germany, or if he had manifest reasons to assume that his goods will be passed on to Germany. Now, this point of fact was not clear, and therefore the Federal Court of Justice sent the case back to the Court of Appeal to establish the facts, whether or not the supplier had reason to assume that his products will be passed on to Germany. But the message is you can be held responsible for infringing a German patent even if you supply some goods just in your country outside of Germany. Thank you for this.
네, 감사합니다. 기업 침해에 대한 최근 연방
Thank you
대법원
very
판결의
much.
내용을 소개해
He
주셨습니다.
introduced
이어서
a case
중국의
about
한
contributory
변호사님께
infringement.
부탁드리겠습니다.
Next, China.
안녕하세요. 예, 중국 리팡루펌 한국 사무소의 한영입니다.
Good afternoon, ladies and
먼저,
gentlemen. I
예,
am Li
공통 질문
Gu-han
일에 대해서
from China.
답변드리겠습니다.
First, I'd like to answer the
중국 법원은
first
특허권이
question.
속지주의에 대해 비교적 엄격한
China
지적 기준을 적용하고
strictly follows the
있으며
territoriality
중국 내에서
principle
발생한
of
침해
patent
행위에
rights,
대해서만 관할합니다.
and Chinese
저희들이
courts
조사에
only
의하면
adjudicates the acts of
저희들이 중국의 최고법원이 아니기
infringement of
때문에
patent
최고법원이
that
아니기
occurred
때문에
only in
저희들이
China.
조사 결과가 100% 정확하다는
But
그런 그 확정은 내릴 수
we
없지만은
cannot make confirmation that the
현재까지
investigation we made is
중국에서는
100%
속지주의에 관하여
perfect. But
특별히
in
이슈가
China,
되었던 대표적인 판례는 없었던 걸로 알고
there's
있습니다.
no representative case where the
그러한 그
territoriality
공통 질문
principle
이해에
brought
대해서
about special issues.
특허의 속지주의
And for
원칙에
the
의해
second
해외에서
question,
발생한 부분에 대해서 중국 법원은
with the rise of
관할 권이 없으며
cross-border
중국
patent
내에서
infringement,
발생한 부분에 대해
actually
관할하게
for
될
the
경우에는 간접 침해에
patent
해당할 것입니다.
infringement cases
현재
that occurred abroad,
중국
Chinese courts have no
특허법은
right to
간접 침해에 대해
adjudicate
명확한
upon
규정을
such
두고 있지
cases.
않으며
The Chinese
사법
court
해석과 중국
does not have
각 지방 법원
special
내부의 판결
regulation
규칙만
or
근거로 하고
law
있습니다.
on
예컨대
or explicit provisions on
2017년
indirect
베이징시
infringement.
고급법원이
But in
특허 침해 판정 지침,
2017,
그다음
there has been the
2016년도에
guidelines for patent infringement judgment, and in 2016, the
현재
application of law in the trial of patent infringement disputes were
모색
published.
단계에 있으며
Now we are
중국 내
under
간접 침해
review
사건을 다루는 데
on
있어서
the concept of indirect
근거가
infringement,
부족한 상황으로
and
저는
we are
보고
lack
있습니다.
of legal basis
특히
to
국경을 초월하는
handle
특허
the
침해
indirect
사건은
infringement cases,
간접 침해뿐만
especially
아니라
cross-border patent
속지주의도 고려해야
infringement
한다는 점도
cases.
있고
We think we need to
저희
follow
개인적인
territoriality
생각으로는
principle
현재
while considering that issue as indirect
관련
infringement. For
국경을
now,
초월하는 침해 사건을 다루기
the current
어려울
Chinese
것으로 저는 보고 있습니다.
court have
이상입니다.
not sufficient
감사합니다.
legal
중국의
basis to
상황을
deal
잘
with cross-border
설명해
patent
주셨습니다.
infringement
이번에는 한국의
cases.
상황에 대해서 김 판사님께서
Next, we'll
슬라이드
turn
함께
to
설명해 주시겠습니다.
Judge Kim to
예, 특허법원
for Korean
김광남입니다.
cases.
종전에는 저는 보통
I'm
저기
Kim Gwang-nam
뒷좌석이나
from Patent
아니면은
Court of Korea.
사회자석에 서
Usually I
있었는데요.
used to sit
살다 보니
among the audience
패널
and the
자리에
floor,
앉게 되어
but
감개가
now
무량합니다.
I got the opportunity to
또한
be one
평소
of the
존경하던
panels,
국내
and
판사님들과
I'm
전 세계
honored to
전명한
be the
판사님,
panel.
교수님,
And I'm
변호사님과
honored to
함께하여
be
매우
with
즐겁습니다. 답변을 드리도록
the
하겠습니다.
world-renowned judges, and
국내에서 속지주의
I'd
원칙은
like to answer
다양한
the
국면에서
question.
쟁점화된 바
In
있습니다.
Korea,
시간
the
관계상 자세한 내용은
territoriality
자료집을 참조해 주시길 바라고
have been
저는 오늘 이
very
자리에서
important
여러 번
issue.
다루게 될 세
Here,
개의
I
사례에
would
대해
like to talk about
소개시켜드리도록
three
하겠습니다.
case examples
먼저
that we're going to deal
감강 드럼
with.
사건입니다.
The first one
감강
is
드럼은 레이저
the
프린터에 사용되는
one of
소모품 중
the
하나입니다.
drum-related case
레이저
that
프린터의
is used
원리는
for
레이저의
laser
전하를 받은
print.
드럼이 관광을 일으키게 되고 관광된 부분에 토너를
So-
붙은 후 토너를 종이에 옮기면 열을 가하여 종이 위에 고착시키는 것입니다.
So
다들
it
뭔
has a
소리냐
specific
싶게 하는
mechanism
표정인데요.
of
쉽게
the 3D
말씀드리면
printer
토너가 잉크를
working.
제공한다면
So easily
감강
put,
드럼은
the toner provides ink,
프린트
and the
이미지를 형성하는
drum
도구입니다.
shapes the
바로 이
image of
그림에
the
나오는
print,
이
as you
화면일
see
것
on
같은데요.
the slide. This is
감강 드럼
how
사건은
the
레이저
3D
프린터에
printer
관한
works.
특허에서 해당 발명에만 사용할 수 있는
It is
감강
related to
드럼을
the
생산하는
patent on
행위가
laser print
간접 침해가
and
해당하는지
production
여부가
of
문제된 사안입니다.
the
한국
laser.
특허법은 침해 행위가
was
업으로서
actually one of the
행하여야 할
cases where we
것을
thought
요구합니다.
it could
따라서
be
레이저
indirect
프린터의 소모품인
infringement.
관광 드럼을 일반 소비자가 구입하여 장착한다 해도
So
업으로서
even
한 것이
if the
아니라면
general
직접 침해
consumer
행위가
buys
되지
the
않는다고 볼
drum
여지도 있습니다.
and use
하지만
it for 3D
대법원은
printer,
그
that is not
전
direct
단계인
infringement.
드럼을 생산하는
but
행위에 대해서
regarding the
업으로서
act of
행하였다면
producing
간접
drum,
침해에 해당한다고
that could
판시하였습니다.
be regarded as infringement.
다음은 양방향 슬라이드
And
폰
next
사건입니다.
is
이 사건
two-way
발명은 말
slider
그대로
phone
양방향
case.
슬라이드 폰입니다.
This is
앞면을 위로
literally the
올리면 키패드가
two-way
보이고
slider
앞면을
phone
아래로
case.
내리면
If you
게임용 패드가
put the
나옵니다.
slide up
피고는
and down, you
국내에서
see
반제품을
different
생산합니다.
functions on the phone.
예, 즉 미완성 제품을
So the
생산하는
defendant
것이고요.
produced
그림에서 보시는 바와
semi-finished
같이
mobile
키패드가 전혀
phones.
장착되어
And
있지
in the
않습니다.
semi-finished
그리고 이를
mobile phone, there's
해외로
no
수출한 후
keypad.
해외
They
계열사가
export
이를
this to an
완제품으로
overseas
완성한
company,
사안입니다.
and that overseas affiliate
대법원은
manufactures
본
that
사안에서
as a
속지주의를
finished
이유로
product.
반제품
Due
생산이
to territoriality
간접 침해에
principle,
간접
this
침해가
case-
성립되지 않는다고 판시한 바 있습니다.
for this case, it's not
예,
indirect
마지막은
infringement.
의료용실
Lastly,
삽입 장치
the
사건입니다.
medical thread insertion
힘들고
device.
지친 어느 날 문득 거울을 보면
One day,
이
if you
시술이
look
생각나는
into
분들도
mirror,
있을 수
you
있을
may think
것입니다.
of receiving this
바로
kind of
안면
procedure.
리프팅 시술인데요.
It's a
안면 리프팅
facelifting
시술이란 얼굴에
procedure.
늘어지거나 주름진 피부를
Facelifting
당겨주어
procedure is to
탄력
lift
있는 피부를
the
만들고
the
주름을
wrinkled
제거하는
skin,
아주 놀라운 시술을 말합니다.
and actually
본
it
시술은
removes the wrinkles on your face.
그 실이 들어갈 곳과 나올 곳에 각각 구멍을
On the
뚫은 후
location,
실을 넣고
there are
당긴
several
후에
locations,
실이
as you
빠지지
see on the
않도록
picture,
매듭을 지운 후
where the
봉합하는
thread
등의
goes in and comes out.
그런 과정이 필요했는데요. 이 사건 특허 발명은
And the patent
의료용 실의
invention of
기지체를
this case
형성하여 매듭 작업이 필요 없는 실 삽입 장치에 관한 것이었습니다.
is related to
쉽게
the
말해서
thread
얼굴에
insertion
구멍 하나를 덜
device.
뚫을 수 있게 하는
For example,
것이었고요.
it can reduce
이
the
사건
number
특허
of
발명은
holes
조안에서 보시다시피
on your
여러
face.
구성 요소로 구성되어
As you see on
있습니다.
the drawing, there are many
이중 A가
components.
국내에서 일부를 생산을
A
했습니다.
has produced some of the
그리고
device in
A로부터 의뢰를 받은
Korea,
B가
and
국내에서
B
나머지를 생산을 하고
produced the
이를
rest of the kits
해외에
in
있는
Korea,
C에게 공급하는
and
사안입니다.
that
C가
was
아주
provided
환하게
to
웃고
C
있죠.
in
예,
overseas
양손으로
countries. C is smiling.
엄지척을 할 정도인데요. 이렇게 C가 기뻐할
So
정도로
C
이
is
사건
very
발명은
pleased,
부품들만 전부 가지고 있다면은
satisfied with the
이들의 결합은
product.
매우 간단하고 쉬운 사안이었습니다.
By
대법원은
using
본
the
사안에서
two
이
A
사건
and B's
특허를
components,
침해하였다고 판시하였습니다.
the C can
보다
easily
자세한
combine the
범위는
two
해당
components
질문에
and
대한
make a
답변에서 설명해
product,
드리도록
which
하겠습니다.
could be an infringement of patent.
네, 감사합니다. 상세한 사실관계를
Thank you very
말씀드려서
much
오늘 계속
for your
소개될 이 세
explanation
판결에
and
대해서 여러분들께서
provision
이해하시는
of
데 큰
facts.
도움이
I
되리라고
think his
생각합니다.
answer will help you a lot
다음은 미국의 칼슈테트
to understand
교수님께
the
미국에
issue.
대한
Now we
정보를
will turn to
부탁드리겠습니다.
Professor Karstedt.
Hello, and thank you very much for having me at this conference. It's quite an honor to be a part of this group with judges and practitioners all over the world. As Judge Bakker said, it is indeed very late in the United States here in Washington. I put a background here for to make it look like the day, but it's actually 2:30 a.m. But I'm very nocturnal, so I'm okay with this time, and I'm surviving with some coffee, but it's going well. So once again, thanks so much for having me and for a chance to talk about the law of patent extraterritoriality in the United States. In the United States, there's a presumption against extraterritorial application of U.S. laws, and it's a broad presumption. It doesn't just apply to patent law, it applies to U.S. statutes in general, but applies with particular force to patent law because patent law is so tied to the sovereign. The presumption can be overcome explicitly by legislation. So the two examples I'll talk about are the general infringement statute and an interesting case of kind of cross-border activity in one, which is a specialized statute where the presumption was in fact overcome. So the first case I'm going to talk about is a general infringement statute, section 271A of United States Code, section Title 35. This is a famous Blackberry case called NTP versus Research in Motion. The Blackberry case had two types of claims, method claims and system claims, and the servers of the accused device were split across the United States and Canada. And that created one of the territoriality problems in the case. The Federal Circuit, the Court of Appeals responsible for patent cases, decided the case in a very interesting way. It said that the method claim cannot be infringed if any performance, any step of the method claim is carried out outside the United States. So because some steps are carried out by the server in Canada, there could be no infringement by the territoriality principle. However, for the system claim, the court reached a different result. And even though some parts of the system exist in the United States, a user in the United States who benefited from the system, such as a BlackBerry user, would be considered a direct infringer of the patent, and therefore a system claim could in fact be infringed, even though parts of the accused server were split across two different countries. So this is an example under the general infringement statute 271A. I'm going to skip some of the material in my answer because I think Judge Jordan will cover some of it, and some of it is maybe less critical, to go to my next example, which is section 271F. And this section deals with supplying components of a patented invention from the US for assembly abroad. There was a case in the 1970s called Deep South where it was a shrimp, removing veins from shrimp, and the assembly was supplied from the United States to Italy, could be quickly put together into an infringing device, and basically performed operations that were patented. The court said that's not an infringement because the assembly was never put together in the United States. Congress thought that was a loophole and it overturned it, and it said that it's an act of infringement to supply from the United States all or a substantial portion of the components of the patented invention. So the result in that case, in the Deep South case, would be a return. If the components were combined, the device would meet the limitations of the claims. In addition, it's also an infringement to supply any component, especially made or adapted for use in the invention. Two things to realize about the statute: it does not apply to method claims, it applies only to systems. So again, with systems, there's maybe a little bit more liberal approach to territoriality, more patent-friendly approach. But the other questions, of course, the United States Supreme Court had to decide are what are components of the patented invention. In one case, Microsoft versus AT&T, the court concluded that software executed on a computer was not a component. An actual software disk could be, but once the software disk was sent abroad and copied, it was no longer a component. And therefore, the statute did not apply in that case, right? And there was no supplying of components of the patented invention in that case because the software was copied. Only a master disk could be a component, not a copy of the software. A second case, so as you can see, a lot of these cases are software cases, but there's also a biochemical case called LifeTech versus Promega. There, the defendant supplied a particular enzyme for polymerization and tried to argue that that's a substantial portion of the components of the patented invention. The court said no, as a matter of law, one part of the invention could not be a substantial portion of the components. It had to be more than one. So just one piece of the invention was not enough. The contours of the statutes are still being developed, but these are two cases that went the other way, one against the patentee, which shows still that the extraterritoriality principle in the United States is quite strict, and you really need the perfect case for all the pieces of the assembly are shipped abroad for being put together in another country. So I think I'm going to end my answer to this question there, and we'll discuss some other implications of U.S. extraterritoriality in further questions. Thank you.
네, 감사합니다. 미국의
Thank you
상황을
very
다양한
much.
사례와 함께
He gave us
설명드렸습니다.
various cases, many cases
영상으로
in
보내주신
the
조던
U.S.
판사님께
Now we will
미국에
turn
대한
to
정보를 정부가
Judge
요청해서
Jordan.
듣겠습니다.
He will tell us
영상
his answer
부탁드립니다.
via the video.
This is Kent Jordan again of the United States Court of Appeals for the Third Circuit. I'm participating at this point in session 4, dealing with cross-border issues and IP enforcement. First, I want to say thank you again to the organizers of the International IP Court Conference for inviting me. I would very much like to have been with you in person, but I'm happy to participate even remotely, and hope that at one point we can all be together in person. I understand that this panel is focused on the extraterritoriality of patent laws and other cross-border issues, and I plan to speak on them in relation to U.S. laws, particularly regarding the assertion of infringement that may occur in some measure outside the United States, as well as the ability to claim infringement damages related to losses occurring outside the United States. I'd be remiss in this session, as I wanted to say in the previous session, session 3, that I appreciate the help of my law clerks who provided so much assistance in the preparation of what I'm sharing with you today. So, part 1, infringement. Questions 1 and 2 are the ones I'll answer in this portion. Question 1 reads, please give an outline of any incidents or judicial precedents on patent rights related to the territoriality principle that have been debated in your country. And question 2 asks, with the rise of cross-border patent infringement, please share your views on whether your country's existing laws can sufficiently regulate patent infringement, and give an outline of examples where cases expanded or narrowed the scope of infringement. Look, as a background principle, although the United States Congress has the ability to exercise its powers to some degree outside the United States, U.S. law is presumed to not have extraterritorial reach. There are many policy reasons to be cautious about asserting U.S. Laws abroad, including mindfulness of international law, respecting principles of comity, and tending to the separation of powers between the executive and legislative branches of our government. In the intellectual property context, extraterritorial reach can mean many things, some of which are well established and not in tension with extraterritoriality concerns, such as the fact that foreign activities can serve as prior art and preclude the granting of a U.S. patent application. Regarding the enforcement of patents abroad, however, the Supreme Court has instructed that the presumption that United States law governs domestically but does not rule the world applies with particular force in patent law. Indeed, basic patent infringement is statutorily defined as having to occur within the United States. And a well-known author of a U.S. patent law treatise has written that of the 3 principal forms of intellectual property, patent rights are the most explicitly territorial. There is, however, a more recently codified form of infringement directed at the intentional shipping of parts outside the United States to be combined in an infringing way. This provision of the U.S. Code states that whoever without authority supplies or causes to be supplied in or from the United States all or a substantial portion of the components of a patent and invention, where such components are uncombined in whole or in part, in such manner as to actively induce the combination of such components outside the United States in a manner that would infringe the patent if such combination occurred within the United States, shall be liable as an infringer. In other words, exporting components from the U.S. with the purpose of combining them in an infringing way is infringement. This was added by Congress in 1984 to the Patent Act in response to a decision by the Supreme Court which had held that such action was not infringement. This provision, which is codified at 35 U.S. Code Section 271F, is explicitly intended to address actions that begin in the United States but end in foreign places. And the Supreme Court has emphasized that it be interpreted in light of the general presumption against extraterritoriality of U.S. laws. The court has also held that the assessment of what constitutes a substantial portion of the patented technology cannot be a single component. You can't say substantial proportion and have one component count as a substantial portion, because the assessment, the court says, is quantitative and not qualitative. Over the last few decades, the Federal Circuit has developed a body of case law interpreting 271F in the context of these extraterritoriality principles. For instance, it is found that there is no infringement over the internet where infringement happens at servers around the world. It is held that the infringement provision regarding shipping parts abroad to be combined does not apply to method claims, and it has interpreted a different provision, that is 271G, which covers importation of infringing goods, to only cover tangible products, not data or other intangible things. On the other hand, the standard U.S. infringement provision, section 271A, which on its face requires acts of infringement to occur here in the United States, can incorporate extraterritorial acts when the U.S. is the place where control of the system is exercised and where beneficial use of the system is obtained, that is, if there's a patented system. Offers and negotiations to sell infringing goods when such offers took place outside the United States can constitute infringement when the actual sale would happen in the United States. If it happens here, yeah, there's a problem. This is because we understand infringements to occur at the location of the contemplated sale. So those overseas offers for sale in the United States will constitute infringement. I hasten to add, let me first note that the inverse of what I just said is not true. Domestic negotiations to sell abroad are not infringing. But that's where I want to emphasize that if a negotiation becomes an offer to sell here, that would be an act of infringement. Lastly, inducement to infringe under 271B can occur abroad, meaning that acts outside the United States that induce infringing acts in the U.S., such as shipping components into the U.S. with the intent that they be combined in an infringing way, can constitute infringement. This extends beyond personally importing a product and includes inducing a customer to import an infringing product. As you can tell from this brief overview, maybe not as brief as you'd have liked, the law on the extraterritorial enforcement of U.S. patents is variable, dependent on both the statutory limitations on patent infringement to acts within or directed to the United States, as well as the general presumption against the extraterritorial enforcement of American laws. There are specific ways that one can infringe a U.S. patent abroad, for instance, by inducing infringement in the United States, by exporting the components with the intent of combining them in an infringing way, or attempting to import goods into the United States. But even these examples of extraterritorial reach are seen as domestic enforcement of patent laws. Now, that's because all these applications are targeted at actual conduct occurring in the United States, or at conduct that, while it may occur elsewhere in the world, involves steps taken with the intended result being infringement within the United States. Conduct out the United States that is not directed at contemplated or actual infringing action within the U.S. cannot violate American patent law.
네, 감사드립니다.
Thank you very
교수님과 조동
much. We
판사님께서
heard from Professor
미국의
Krashtat
법제와
and
판례를
Judge
상세하게 말씀해 주셨습니다. 결국
Jordan
역의 적용 문제를
about
별도로
the
명확하게
cases
흉내 유지 없이 해결하기 위해서
that in the US
271조
to deal
F하기라는
with
별도의 규정을 발현했고 그 조문의 해석 범위를 어떻게
territoriality
볼
principle,
것인지에 관해서
the
다양한
US has
사례가
established
전개되고 있음을 말씀해 주셨습니다.
271.F
그러면
provision.
이번에는
And thank you very
다음
much for your answer.
질문으로
Now let's
넘어가겠습니다.
move on to the next
첫 번째 큰
question.
주제에서 이번에 다루게 될 질문은
The next question
3번
is
질문입니다.
number 3.
간접 침해와 직접
Regarding
침해의
the
관계에 대한
correlation between
질문이겠습니다.
indirect
잘
infringement and
아시다시피
the direct
국경을 넘는
infringement,
특허 침해
there has been a
문제는
lot of
간접
discussion on
침해가
whether direct
연계되어서
infringement
밀접하게
must be
관련되는 문제로
established
항상
as a
제기가 됩니다.
prerequisite to
그런데
establish
간접 침해가
indirect
인정되기 위해서
infringement.
반드시
This
직접
is an
침해가
important
전제로
issue
되어야
in a
되는가, 이
cross-border
부분에 대한 논의가
IP infringement
각국에서 다소
issue.
다른
So
양상으로
please
전개되고
align the
있고
approach
판례의 태도도 좀
to this
다르다고
matter
알고
under
있습니다.
your country's
이
law
부분에
and
대해서
introduce
각국의
specific
연사분들께
cases. So we
정보를
will hear
요청드리겠습니다.
answers from
이번에는
each
중국의
country.
한 변호사님께
First,
먼저 부탁드리겠습니다.
Mr. Han,
예, 답변드리겠습니다. 사실
Actually,
특허법이나 사법
the
해석에는
Chinese
간접
patent
침해라는 용어가
law
없습니다.
does not contain the
이
term
용어는
indirect
특허법에 유래된
infringement.
것입니다.
Indirect
간접
infringement
침해
comes
행위에
from
대해
the
중국
US.
법원은 통상적으로
In practice,
민법상의 공동 침해 이론을
the
적용하고
joint
있습니다.
infringement rule in civil law
중국
is
최고법원이
applied when handling
2016년도
indirect
사법
infringement.
해석에서는 간접 침해를
2016,
방조형 간접 침해와
Indirect
조사형
infringement
간접
was
침해로
divided
구분하고
into
있지만
contributory
실제상에서는 이 사법
infringement
해석의
and
규정도
indirect
권리 침해 책임법에 기초한 것입니다. 권리 침해
infringement.
책임법에 규정된 연대 책임으로부터 알 수
So
있다시피
this is
간접
actually
침해는 직접 침해가
defined.
실제로 발생한 것을 전제 조건으로 합니다.
Actually, it is
그 밖에
under the condition
중국
that the
특수계에는 간접 침해에 대해 두
indirect
가지 이론이 있습니다.
infringement,
하나는 종속설이고 다른 하나는 독립설입니다.
the occurrence
아시다시피
of direct
종속설이란
infringement
간접
is
침해는
determined to be a
직접 침해에
precondition for
종속되며
indirect
직접 침해의
infringement.
발생을 여건을 한다는 것입니다.
And there are two
이와
theories
반대로
about indirect infringement.
독립설이란
One is
간접 침해는
dependence theory, and the other is
직접 침해로부터 독립되어
independence
있다는
theory,
관점인 바
which says that
직접 침해의
indirect
발생을
infringement
여건으로
is
하지 않는다는
independent
것입니다.
of direct infringement,
하지만
and it can be
대부분의 중국
established as long
학자들은
as the
종속설을
condition for
지지하고 있는
indirect
것으로 알고
infringement
있습니다.
are met. But
그다음
most Chinese
중국
scholars,
사법
they
실무에서도
support the
대부분의
dependence
판례는
theory.
직접 침해의
And
발생을
in Chinese
간접
judicial
침해의 전제
practice,
조건으로 하고
in most
있지만
of the cases,
간혹 가다가
the
예외적인 판례도
precondition for
존재하는 걸로
indirect
알고 있습니다.
infringement is direct
예컨대
infringement, but there are some
중국
other
특허능
cases.
회사와
For
C4
example,
회사라고 이
in
둘 다
the
중국 회사입니다.
case
이
between
두 회사
Talent
간에
Company
발생한
and Super
신용 신한 분쟁
Company,
사건에
the two
있어서
companies are both
중국
Chinese
강서성
company had a
고급법원 상해
dispute.
남쪽에는 상해 주변의
They-
그 성인데요. 여기 고급법원에서
In the
2016년도에
High Court,
판결한
High People's Court,
내용에
in the
의하면
location where they were operating,
여기에서는
they
전용품 조건에
determined
근거하여
that
직접 침해 존재
indirect
여부를
infringement was
고려하지 않은 상황에서
established based on the condition
간접
of
침해
special
성립을
use
판시한 바 있습니다.
products, regardless of whether direct
감사드립니다.
infringement has occurred.
이번에는 한국의 상황에
thank
대해서
you very much. Now we will turn
부탁드리겠습니다.
to Judge Jung.
예, 특허법원의 정유영 판사입니다.
I'm
이렇게
Young
뜻깊은
Jung,
자리에서
Judge
발제를
of
맡게 돼서
Patent
진심으로
Court. It is my
영광으로
honor
생각합니다.
to answer the question in this
간접 침해
conference.
성립에 직접 침해가 요구되는지
question,
관련해서
regarding the
관련
question,
규정인 우리 특허법
Let me
129조의
introduce
규정에는
you
명문의
the
내용이
Article
포함되어 있지는
127 of the
않습니다.
Patent
학설은
Act,
불분하고요.
but it
관련해서
doesn't
대법원은
clearly
감정드럼
mention
사건에서
the
특허 관련인
correlation.
레이저 프린터에 전용되는
And there is a
소모품인
case,
토너 카트리지의 생산
the case
판매
involves
행위가
toner
간접 침해에
cartridge
해당한다고 판단을 하면서도
and
이를 이용한
photosensitive drum
레이저
cartridges.
프린터의 최종
And in this
소비자의
case,
행위가
the
직접
infringement was
침해에
recognized,
해당하는지에 대해서는
and
판단하지
whether it is a
않았습니다.
direct infringement
이
was
경우에
not
최종
established.
소비자의 행위는
In this
대체적으로
case, the
개인적이고
final
가정적인
consumers
실시에 해당할 확률이
act
많아서 우리
was made by
특허법상
accident,
직접
so the
침해에
Korean
해당하지 않을
Patent
확률이
Act
있기
does
때문에
not
그런
recognize it
상황과
as a
우리
infringement
대법원의
of a
태도가
patent. So
간접
the Supreme
침해의
Court
성립에
attitude
직접 침해가 요구되지
may be
않는다라는
understood
입장을 취한
that
것이 아닌가 하는
indirect
해석이라
infringement doesn't
나타났습니다.
require, there is no
하지만 반면에
correlation between
양방향
indirect
슬라이드
infringement
토의
and
사건에서는
direct
대법원은 일부
infringement.
발명의
But in
구성이 결여된
contrast,
상태로
there is another
간제품이
case,
국내에서
which is
생산된
the
경우 간접
cell phone
침해죄의 취지
case.
그리고 속지주의 원칙에 근거해서
Based on
간접
the
침해에 해당하지
territoriality
않는다고
principle,
보았는데요.
the
이러한
indirect
대법원의
infringement
태도는
was
앞서
not
말씀드린
established.
강강드럼 사건의
It
태도와는
is
조금
in
상반된 것이
contrast with the
아닌가라는 그러한
photosensitive
견해가
drum
나타났습니다.
cartridge case.
나아가서 최근 대법원은 방법
And
발명의
recently,
실시권자로부터
Supreme Court decided that a licensee who has obtained permission from the patent right holder concerning process invention requests a third party to manufacture product used only for the practicing of the process, then receives the supply thereof to practice the process invention. The acts of manufacturing or assigning the above product by the third party do not constitute indirect infringement. So there is various opinions regarding the interpretation of the correlation between indirect and direct infringement. And it seems the Supreme Court in Korea decides a case depending on whether the requirements for direct infringement are met. Whether direct infringement is required for indirect infringement is not decided yet. Now we will turn to the U.S. Professor Karlstedt.
All right, thank you again. I will answer then the question dealing with predicate acts of direct infringement for indirect infringement in the U.S. The short answer is yes. In the United States patent law, you have to have a predicate act of the direct infringement in the United States, going back to the territoriality principle, in order to have indirect infringement. In the United States, there are actually two forms of indirect infringement. One is called inducement under Section 271B, and the other one is called contributory infringement, which involves selling or specially made or specially adapted article for the infringement of the patent. Inducement in Section B is more general provision for encouraging or aiding and abetting somebody to infringe a patent. But the predicate act must be there. So just to give you two examples, one actually involves extraterritoriality, where a defendant copied a pressure cooker abroad in Hong Kong and then induced somebody to import it into the United States. That conduct was actionable as inducement because there was an act of import and sale in the United States, which is required for inducement under Section 271B. And more interesting examples have come up with method claims. Perhaps we'll come back to this topic. The Federal Circuit in one case surprisingly said that one can be an inducer of infringement under 271B without anyone being a direct infringer if you perform some steps of a method claim and convince someone else to perform some other steps. The particular case here was a case called Akamai versus Limelight. And in the Akamai case, what happened is, this was not an extraterritoriality case, but a case with conduct fully in the US, but there were two parties. There was a provider of a service that basically relieved pressure in various computer servers by having certain content moved to a third-party storage, third-party server. But the user, for example, a website operator, had to tag the particular content that they wanted stored at another server to relieve the traffic. And the idea there is just basically tell the service what needs to be moved off if there's a very popular video or something like that. So the steps of this method claim were split between two parties, and the Federal Circuit again said you can induce an infringement of a method claim without anyone actually performing all the steps. The Supreme Court said no, that's not possible. You have to have one entity, single entity, perform all the steps of a method claim, whether directly or through an agency relationship, but they have to perform all the steps, and there could not be inducement without direct infringement. So these two cases, the Global Tech case involving a pressure cooker that was imported into the US, and the Akamai case, which said that for a method claim, you have to have a single entity perform all the steps, confirm that there must be a predicate act of direct infringement in order there to be a claim under 271B or 271C for indirect infringement, such as inducement or contributory infringement.
네, 감사합니다. 이번에는 독일의 상황에
Thank
대해서
you very much. Now we will hear about a case
부탁드립니다.
in Germany. Judge Baha.
Well, not a case, but a special section in the German Patent Act. So we also have two different concepts. The first one is the concept which I already mentioned of contributory infringement. It's a broad concept based in German civil law, and it's also applicable in patent cases, of course. And we have another concept, a different concept, which is called indirect infringement. And this is governed in the German Patent Act. It's in Section 10, which was established in 1981, so quite some years ago. And this rule in Section 10 clearly states that it is not necessary to have direct infringement, but it is sufficient to supply or to offer goods if it is obvious that these goods are suitable and intended to use the invention. And if this is the case, then the patentee is entitled at least to get an injunction, even if direct infringement has not occurred so far. However, the patentee is entitled to damages only if there is, and insofar as there is direct infringement. But as I said, you may get an injunction even before direct infringement has occurred based on this Section 10. It applies only to claims which cover products. We have no similar rule for method claims. So if it's for a method patent, you can only refer to this broader concept of contributory infringement, as I explained in this case of this Italian car manufacturer who sold his goods just in Italy and was held liable for infringing, or could be held liable for infringing, a German patent. Thank you.
네, 감사합니다.
Thank you very much.
칼슈타트 교수님과
Professor
바허 판사님을
Karlstadt and
통해서
Judge
미국은
Baha
기본적으로 종속세를
told
기반으로
us that
하고 독일은 그
the U.S.
반대성이
is
독립세를 기반으로 하지만
it's based on
미국의
dependence
경우에
theory,
최종
and
판매 행위지로서 특허 침해가
Germany
완성되는
is in contrast
장소가
with the
미국
U.S.
국내인 경우
And it is
그
also
다양한 형태를
important how
통해서
they are
침해가 인정될 수
important
있는
to decide
그런 규정과
where the
해석을
operation
말씀드렸습니다.
is
그리고
conducted.
독일의 경우에는 좀 더
In the
흥미로운
case of
금지 명령
Germany,
외에
it is very
간접
interesting
침해가
that
인정되더라도 손해배상을 어떻게 산정할 것인가의 단초에 대한 말씀을
how
해주셨는데
damages are
이 부분은
calculated
향후에
is very
다시 좀
important.
더
We will
논의해 볼 수 있는
discuss
그런
this
기회가
issue
있었으면
in
좋겠습니다.
the future if
자,
we have
이제
more time.
다음 슬라이드로
Now let's move on to the next
4번
slide.
질문입니다.
Number
4번
4,
질문은
question number 4.
간략하게 사례를 상정해서
In this
각국의
question,
의견을
we'd like to hear
여쭤보도록 하겠습니다.
some
지금
cases from
상정하는
each country.
사례는 단일
We will give
주체가
you
모든 행위를 수행하였다고 가정하는 질문이
Case or
되겠습니다.
example.
세
Let's
가지의
say a
세부적인
single
질문이
entity
포함되어
did
있습니다.
everything. There are three
첫 번째는
specific
물건
questions.
발명이고 두
The first
번째는
is
방법
about
발명을 전제로 합니다.
product invention.
첫
The second
번째와 두 번째는 모두
presumes
발명의
process
구성 요소
inventions. The
일부만
two
국내에서 수행이 되거나
says
생산이 되고
only part of the
수출된
method
후에
were conducted
해외에서
domestically,
나머지
and
구성
after
요소가
export,
생산되거나
all the
수행된
rest
경우
of the components
이러한
were
경우에 특허
conducted or
침해가 성립할
assembled.
수
Does it
있는지를
constitute
질문드립니다.
infringement
세
of a
번째는
patent?
물건 발명에
Question number
관해서
3
조금 더
is
특수한
about
사례를
product
질문드리겠습니다.
inventions. It's more
국내에서
specific. It's
수행된
more of a
부분이
specific question.
구성 요소의 거의 대부분을 수행한
Let's say if a
것이어서
substantial portion of a
사실상
production is completed
완제품에
and
가까운
semi-finished
반제품을
products with
생산한
the key
것이고
features were produced in your
수출된
country,
후에
and these
외국에서
semi-finished
수행되는
products go
나머지
through
구성
minor
요소는
processing to
매우
produce
사소한
finished
가공에
products
불과한 경우
overseas.
이런 사안을 전제로
Would this
특허
constitute
침해가
patent
성립하는지를
infringement?
질문드리는 내용이 되겠습니다. 자, 그러면 이번에는 먼저
Now,
한국의 김 판사님께
We will hear
답변을
from
부탁드리겠습니다.
Judge Kim first.
네, 답변 드리겠습니다. 먼저 4-1 사안과 관련해서 대법원은
First, for
양방향 슬라이드
4-4
사건에서 간접 침해에 해당하지
in the
않는다고
two
판시를
sliding
하였습니다.
mobile phone
즉
case,
간접
is
침해의
that it
의의와 한계에
doesn't
대해서 대법원은
constitute
특허권이
indirect
부당하게 확장하지
infringement,
아니하는 범위에서
saying
그
that
실효성을
within the
확보하기
scope
위한
that the
것인데
patent right
본
is not
사안은
extended to the
국제주의
unfair
원칙상
level,
완제품이
and due
해외에서
to the
생산되는 이상
territoriality
그
principle,
전 단계의
if the product
반제품이
was
국내에서
produced
생산되더라도
overseas, so
간접
even
침해가
if the previous process was done in Korea, that case cannot be regarded as indirect infringement.
계열회사 관계였는데요.
In this case,
법률상
the
완전한 동일인이라고
producer
하더라도
of
결론이 달라지지는
domestic
않았을 것이라고
semi-finished
생각이
product
됩니다.
producer and the
다음으로
overseas finished product producer
방법 발명
were the
사안과
overseas
관련해서 이
were
점을 명시적으로
affiliates,
판단하고 있는 대법원 판결은 발견하기가
and it
어려웠습니다.
was difficult to
다만
find the
하급심에서
Supreme Court's
외국 법인의
ruling
한국
that made
자회사가
a very clear
해외에
decision
위치한
on
외국
this.
법인의 소유의 서버를 이용해서
There was a
방법
company
발명을
that
침해한
used
행위에
the
대해
server
해당
located in
발명의 구현
overseas
방법,
country
목적,
and
작용 효과 등을
infringed on the
고려하여
method
국내
of
실시를
patent.
인정한 바가 있습니다.
At that
즉
time,
하급심에서는
the
서비스의 지우 단계가
patent
국내의
license in
사용자의
Korea was
컴퓨터에서
recognized.
피고
So the
웹사이트를 통해
local
구현되고
user's
그로 인해
computer
피고가 수익을 얻는
was
점등을
used,
고려한 것으로
and
보입니다.
it used a
마지막
server
사안과
located in
관련해서는
overseas.
마찬가지로
And
명시적으로 판단하고 있는
lastly,
사안을 찾을 수가 없었는데요.
I could not
사견으로는
find the
극히 예외적인
clear
경우에 그리고
judgment
동일인에 의한
cases,
경우라면
but if
구체적
the act
타당성을
was
위해
done by
아주
the same
제한적으로
single
직접
person,
침해
then
행위로
it could
인정할 수
be
있는 경우도
regarded
있을
as
수는 있을 거라 생각이 듭니다.
direct
네, 설명
infringement.
감사합니다.
Thank you for your
이어서
explanation.
미국의 칼슈테트
Next,
교수님께
Professor
미국의
Karlstedt.
상황에 대해서 질문드리겠습니다.
Please tell us about the case in the U.S.
Sure. The relevant provision here, once again, is the one that Judge Jordan and I already talked about. This is Section 271F, which redefines direct infringement as supplying a substantial component, all substantial portion of the components of the patented invention, so as to actively induce a combination on the United States. So the act of supplying actually completes the infringement here. And so you asked me to talk about process inventions and then product inventions. So for process inventions, and this is, we'll jump to 4.2, the answer is actually quite simple, right? This section simply does not apply to process inventions, as is based on cases like NTP and cardiac pacemakers, which I mentioned in the slides and in the notes. So we'll focus on product inventions. With product inventions, it's a complicated issue, right? You have to supply all or substantial portion of the components of the patented invention. So in the first example you gave, if some of the parts are required to practice the invention and manufactured in this country, and the remaining parts along with the assembly of the finished product is performed overseas, you'd have to decide if this is a substantial portion of the components of the invention. We know that one component is not enough, right, from the LifeTech case, but you can have more if basically all the components or most of the components are shipped overseas and then assembled there. That could be sufficient, right? And in addition, right, the other limit to the statute is under 271F2 is that something is especially made for the use in the invention, and these could also be significant limits. Now, in your example, in the comment question 4.3, you have right, substantial production is completed and semi-finished products with key features are produced in your country. I think that's an easy case for the application of 271F, either subsection 1 or 2, so where you supply a substantial portion of the components, or you supply basically a part of the device that's especially made to be infringing when it's put together. So if it's just basically semi-finished products and only minor work is required, that'll likely be infringement under section 271F. So to summarize briefly, for process inventions, no infringement is possible. For product inventions, in your first question 4.1, I think it'll be a close call depending on the facts. I think in 4.3, the case is probably an easy one for applying 271F, which had happened in cases like Deep South, which was intended to be overruled by 271F with the shrimp devaner, and in cases like Western GECO, where these DigDefend devices were basically ready to be combined outside the US, and that's probably an example of 4.3. Thank you.
네, 감사드립니다. 예, 계속 반복해서 설명해 주셨듯이 271조 F를 적용하고 이 해석론을 어떻게 전개하냐에 따라서 여기저기 문제가 손쉽게 해결되는 여지가 있고
will provide an answer to this territorial principle issues and cross-border IP issues. Now we will turn to Judge Bach. We will ask him the same question.
Thank you once again. Now, we don't have a special provision in the German Patent Act dealing with these questions, and there is not too much case law either on this question. So I can give you some general remarks based on my personal opinion. So for the first question, if a product is only manufactured partially in Germany and it is finished somewhere else, in a nutshell, this will not infringe a German patent because, well, the act of infringement has to take place in Germany, and as long as the product has not been finished, normally we will not have an act of infringement. We don't have this special rule like the US, and so I think in the case of question 1, German courts will come to the conclusion that the patent has not been infringed. Things may look differently, perhaps a little bit surprising, on patents covering methods. Again, there is no case law and there are no special provisions, but there has been some discussion in Germany whether it is necessary that all the steps of a protected method have to be performed in Germany. And there has been some other discussion on the questions, what does it mean to perform a step of a protected method in Germany? So if someone sitting in Germany starts a computer which is located in Italy or Korea, does this step take place in Korea or in Italy because the computer is located there? Or does it take place in Germany because the person who controls it, is located in Germany? And I think many cases will be solved by these aspects, by, defining that it is a step which effectively takes place in Germany. And in my personal view, many patentees are able to circumvent this problem by tailoring their method claims in order to isolate single steps of the protected method and to ensure that all these steps must take place in one country and must take place in Germany. And maybe that's one reason why we don't have case law or too much case law on this question. Now the third question may also be answered differently than the first. We have a recent decision which does not cover transnational or transborder infringement, but which I think could be applicable also in this context. And this decision said if someone supplies a product which under economic aspects can really only be used to manufacture a patented product, and by, as typed in question 4.3, by just minor processing, by adding some minor ingredients or what else, then already supplying this semi-finished or let's say a product which is finished at least by 80 or 90 or 95%, then supplying this product already constitutes an act of direct infringement. I think this may sound similar to the statutory rule which our colleagues in the US have, but this is based on case law only. And as I mentioned, this case, the case from the Federal Court of Justice, did not deal with finishing the product abroad, but as they said, already supplying this semi-finished product is an act of direct infringement. I think it may also apply when this semi-finished product is exported to another country, and therefore in the scenario of question 4.3, an act of direct infringement might occur.
네. 감사합니다.
Thank you very much.
독일에서 속주주의 원칙을 엄격하게 적용하고자 하는 그런
I
원칙이 있다는
understand
말씀과
that
최종 판매지가 독일로
Germany sticks to the principle of territoriality.
실효가 일어나는 상황에 대한
He
구체적
also
타당성 있는 해결을
explained
동시에
how we
고려하시는
should deal with
사안에 대한 설명을 해주신
the
것
export
같습니다.
of semi.
자, 이번에는
finished products.
중국의 한 변호사님께
Now we will
중국에
turn
대한 정보를
to
부탁드리겠습니다.
Mr. Han.
먼저 공통 질문 4-1에 대해서 답변드리겠습니다.
First, for the first
저희들이
question,
조사 결과에 의하면
according to
현재까지
our
이에 관련된
research,
구체적인 판례는 없는
there
것으로
are
알고
no
있습니다.
specifically relevant
직접
cases.
침해가 해외에서 발생한
If
경우
indirect
특허의
infringement
지역성,
occurred
중국 법원이
overseas,
관할 등 문제점이 존재합니다.
there are issues like the territoriality of the patent and the jurisdiction of the Chinese court.
침해를 다룰
And
경우에는
if Chinese
중국
courts
내에서 발생한
adopt
행위에
the
대해서만 권리 침해라고
independence
판단할 수
theory to
있지만
determine
중국 사법
indirect
실무에서는
infringement,
주로
it could
정속서를
make the
채택하고 있기에
infringement determination
직접
based on the
침해의
act
발생을 전제 조건으로
occurring in
합니다.
China. But we
같은 말을 자꾸만
mostly
주고 하는데요.
adopt
예.
the dependence
근데
theory.
사실상
It
2001년에
seems like I am
발표된
repeating the
베이징시
same
고급법원이
thing.
특허 침해 판정에 관한
Actually,
지침에는
According
중국
to a
법률에서
guideline
인정하는
adopted in
직접 침해
2001,
행위가 해외에서
it says that
발생하였거나
direct
발생할 가능성이
infringement,
있을 경우
according
간접
to
침해 행위자에 대해
determined
직접
according to
침해 책임을
Chinese
추궁할
law,
수 있다.
occurred
이러한 규정이
or
명확한
may
규정이
occur
있었습니다.
overseas, the
그런데 이
indirect
지침은
infringer
이미
can be held
2014년도에
directly
폐지되었습니다.
liable. But
왜
that
이러한
guideline was
처음에 지침을
abolished
작성했는지,
in
그다음 왜서
2013,
폐지됐는지
and
그 구체적인
why
경우에 대해서는
China
저희들이 알 바가
adopted
없습니다.
and
예.
abolished this regulation.
그럼
We
특허권이
also do
지역성으로
not know the
인해
reason.
해외에서의
And
특허
due to
실시
the
행위를 침해 행위라고
territoriality of
인정할 수
patent
없으나
rights, although the
직접 침해가 발생했다고
implementation of
인정할 수는
patents
없으나
overseas cannot be deemed
중국
patent
내에서의 간접
infringement
침해
in
행위는
China,
특허 제품이 해외 수출에
the
대해
domestic
중대한 영향을
indirect
끼칠 수 있다는 점은
infringement of
명백한
patents will
사실입니다.
significantly impact
개인적인
exports
생각으로는
of patented
국경을
products.
초월하는 간접
I
침해를
personally
인정하는지
think that
어떠한 기준으로 어떠한 인정 기준을 채택하는지 이것은
regarding the
단지
criteria or standard
법률 이론
based on
문제뿐만
which we
아니라
determine direct
관계
infringement
국가의
or indirect
기술력, 그다음
infringement
경제 발전 상황,
depends on each
전반적인
country's
산업
economic
정책,
development level,
이것과는 저는
their
밀접한 관계가
industrial
있다고 봅니다.
policy.
예,
So
그다음
it's closely related to the
공동
country's
질문
own
4-2에
circumstances
대한
and context. And
저희들이 조사에 의하면 아직까지
my
이러한
answer to the
사건에서
second
지침으로 되는
question,
판례는 없는
so
것으로
far
알고
we don't
있습니다.
have
즉
such
중국에서는 지금 이
cases in
국경을
China.
초월하는 이러한 그 간접 침해
In
행위에
China,
대한 판례가 거의
we
없는 것으로 아시면
have
될 것
almost
같습니다.
no cases
그다음
related to
여기에서 행위자의
indirect
특권의 행위가
infringement
모두
across
중국 내에서
borders.
발생하였을 경우에는
And if
당연히
the
직접
example
침해로 판단할 수
cases
있습니다.
occurred in China,
다만
we could say
일부
that that's
방법을 해외에서
direct
실시하였을
infringement.
경우에는
But if
특허의
part of the
지역성
method
원칙에
was
의해서
conducted overseas,
중국 법원은
then
직접
due to the
침해로 판단할 수
territoriality
없으며
principle,
간접
the
침해라고
Chinese
판단하기는
court
더욱
cannot
어려울
judge
것으로
whether
보입니다.
direct infringement has
개인적인
occurred.
생각으로는
And I personally
행위자가 만약
think that
주관상에서
if
이게 권리 침해다 이걸 명백히 알면서도
the
중국이 현행 특허법의 규정을
infringer
회피하기 위해서
infringer
의도적으로
knew
해외에서
that his
부분적인
acts
특허를 실시하였고
actually infringed on the
권리자에게
patent
중대한
and
손실을
practiced
초래할
elements
경우에는
of the patented
새로운
process
사법 해석
overseas,
또는
then I
판례로
think the Chinese court
판례
needs
물론
to
중국의
come
일반
up with a
지방 법원의
different
판례가 아니고
precedence,
중국
not
최고
just
법원이
district
판례로
court, but
이러한
maybe the
행위를
Chinese
직접
Supreme
침해로
Court
인정하는 것이
could
저는
recognize
적절하다고
such
봅니다.
act as direct
이게
infringement.
4-1이고요.
And
그다음
my
공통 질문
answer
4-3에
to
대해서
the third
답변드리겠습니다.
question,
예컨대 앞에서 제가 소개해드렸던
as explained
중국 두 회사 간의
previously,
신용 신한 분쟁
the
사건에
case
있어서
between
같은
Talent
그
Company
판례인데요.
and
이
Super
판례에서
Company,
중국 강소성 법원은
the Chinese
직접
court
침해가 틀림없이 또는
mentioned
곧
that
발생하게 될 경우에는
if the
직접
direct
침해를
infringement has
고려하지
occurred
않고
or is likely
바로
to
간접 침해를
occur soon,
구성한다고
then
판결하였습니다. 물론 이건 다 중국
if
내에서
direct
발생하는 일입니다. 이거는
infringement
그런
is
사건이
surely
아니거든요. 중국
about
내에서
to happen, then
간접
indirect
침해든
infringement
직접
is
침해든 이게 다 중국 내에서 발생한
automatically
겁니다.
recognized. This is based
이런
on
판례가
the
있었지만 다만
assumption
중국
that
사법
such
실무에서는
acts occur in
직접
China.
침해의 발생을
But in
간접
our
침해의 전제
practice,
조건으로
direct
하는 것이
infringement is still
주된 경향이기
the
때문에
precondition for
목전이
indirect
중국 법률
infringement.
조건 하에서는
So under
이러한
the
행위를
current laws
침해 행위로
and
판결하기
judicial
어려운 점도
environment,
있어 보입니다.
it's difficult to determine that example case as infringement.
자, 이번에는 다음 슬라이드로 넘어가겠습니다.
Let's move on to the next slide.
복수 주체 과저하는
Next
경우에 대해서
topic is
좀 더
multiple
의견을
entities.
나눠보도록 하겠습니다.
Let's
국경을
talk about
초월하는 특허
multiple
침해가
entities.
국내와 국외에서 각각 다른 주체에 의해서 행위
Assuming
분담으로
that all the
이루어지는
acts
사안을
of
자주
practicing a
발견할 수
patent
있습니다.
registered in your country
이
take
문제를
place within
검토하기
the
위해서
territory
우선
of your
가정적으로
country. If the
한
patent
국가
is
내에서
infringed by
특허 실시 얘기가
multiple
모두
entities
이루어진다는
who will be
전제하에
liable for the
복수 주체의 과저에 의한
infringement
침해를
among the
인정할
multiple
것인지에
entities,
대한 각국의 태도를 먼저
please
질문
introduce judicial
드리겠습니다. 이
precedents
질문에
or
대해서
relevant
이번에는
discussions.
미국의 칼 슈테트
Now I will
교수님께
turn
먼저
to
부탁드립니다.
Professor Karsten first.
Sure. So the controversy over the single entity rule in the United States has been a subject of much discussion, several appellate courts and a Supreme Court decision. Again, as I've talked about before, it's important to distinguish method claims from system claims. So I'm going to start with method claims. With method claims, this particular struggle was to decide when, if multiple entities perform different steps of the method, just like in the example I described earlier with tagging, which in fact was the Akamai case, it's whether those steps can be combined into one act of direct infringement. So the law began with the consideration that if a party is obligated to perform another step by contract or via an agency relationship, that's definitely combinable into one whole act of direct infringement when a party acts as a contractual, kind of contractually obligated party or an agent. And then the courts expanded this rule. The courts expanded this rule to two different areas. One is the idea of joint enterprise, which I think we're going to hear from Judge Bacher as well. In Germany, the purpose of joint enterprise in the United States is described as follows. It's an agreement among the members of the group, a common purpose to be carried out by the group, a community of pecuniary interests in that purpose, and an equal right of voice in the direction of the enterprise. So a true joint venture liability. In those cases, it's possible to infringe a method claims when there are two parties involved. But that's not actually typically what happens in a lot of these cases. A lot of times you have a customer and a service provider, just like with this case I've been talking about with tagging and service, Akamai. There, the court fashioned the notion of vicarious liability. I mean, I'm sure vicarious liability is a familiar concept. It's responsibility for steps of other people, like your, for example, your employees, right, for employer liability and tort. But the court expanded this principle in the method claim context to say when the defendant conditions participation in an activity or receipt of a benefit upon performance or steps of a patented method and establishes the manner of timing of that performance. So this is the most controversial part of sort of attribution theory, the vicarious liability theory. And just to give you another example, this is not in the write-up, but there's a case called Lilly versus Teva, where the basic question was if it's possible to infringe a method claim involving a patient's self-administration of folic acid, of vitamin B12, that would then improve the function of an anti-cancer drug to reduce basically side effects from anti-cancer drugs and chemotherapy. And the court concluded because the doctor is very involved in a patient's self-administration and the doctor can withhold the benefit of the chemotherapeutic drug because the patient didn't take vitamin B12, did not take folic acid, the court said that vicarious liability was satisfied in a context of a doctor-patient relationship, which is kind of interesting, kind of unusual. But again, manner and timing, right? So the doctor would schedule when the person would take folic acid and could withhold the benefit of the activity. In other words, could withhold the treatment if the patient wasn't prepared for the treatment. And so the doctor in that case could be a direct infringement. So this is as far as the method claims go. In the system claims, as I already mentioned, the idea here is the beneficial use of the system or control of the system. Judge Jordan mentioned this NTP case as well, right? The direct infringer is a person who puts a system into operation and obtains a benefit for it, even if the system is split, even if, for example, you're a computer user, but you're receiving their other parts of a server that you're not in control of, but if you're ultimately getting the benefit of the system, and this is a Centillion case, that there's still direct infringement by the user. The court refined this notion in a case called Intellectual Ventures versus Motorola, concluding that the customer or end user must obtain a benefit from each and every element of a claim system. So even if another party has a piece of the system somewhere else, in order for there to be a direct infringement by the user has to obtain a benefit from all the parts of the system and not just some. But for the system claims, again, the rule is different. It's whether you're obtaining the benefit from the whole system as opposed to whether the claim steps for method claims are attributed to one another. I think this is the latest on the state of the law on multi-entity infringement in the United States.
네, 대단히 고맙습니다. 그리고 이번에
Thank you very
독일에
much.
대해서
Now we will
아홉
turn to
판사님께
Germany.
부탁드리겠습니다.
Judge Bach.
Thank you. Again, there is not too much case law in Germany on this question, but the case law we have is quite straightforward. So whenever several entities act together purposefully in infringing a patent, they are jointly liable for infringing this patent. And there is no difference between companies who act together or customer relationships, and there is no difference between method or product patents. So in the most recent case where the Federal Court of Justice dealt with these questions, it was about a patent covering a method for transmitting and receiving a TV broadcast. And so we had two actors, the TV station which broadcast the signals, and the persons who received the signals, who watched TV, to say it in a short way. And the Federal Court of Justice said even it is a customer relationships, these two entities, the TV station and the viewers, act together purposefully, and therefore they are jointly liable for the infringement of this patent. Again, we don't have too many cases dealing with this problem, because in my perception, most of the patents avoid this problem by having two different claims. In this example, one for transmitting and one for receiving the signals, and so each of these methods will be performed by just one entity, and then the question does not arise. But if it arises, it is quite clear, as long as the parties work together purposefully, that they are liable for infringement of the patent.
네, 감사합니다. 네, 미국이나 독일 두 분
The
모두가
US and
사용자의 개입을
Germany
포함해서 말씀해 주셔서
stress
흥미로웠습니다.
the act
이번에는
of the
중국의
final
한
users.
변호사님께
Now we will
부탁드리겠습니다.
turn to Mr. Han.
예, 간략하게 답변드리겠습니다.
I will make my answer brief.
중국에서는
In
구성요소
China,
일체의 원칙에 근거하여
based on
전반적인
the
특허 기술
rule of
방안을
all elements,
실시하는 주체가
the entity who
직접
practices the
침해
whole technical solution of a patent is the
예,
direct
전반적인
infringer.
특허 방안을 실시하는 단일 주체가 없는
If there's no
방법
single
분리
party
침해 사건의
taking all
경우에는
the steps of a
중국
patented
학술계에
method, then
통제와 지휘의 원칙에 따라 특허
we
실시
follow the
주체를
Chinese
판단할 수 있다는
academic
견해가
circles'
존재하고 있습니다.
rule
이상입니다.
of control and
네, 대단히
direction.
고맙습니다. 이번에는 한국의
And
상황에 대해서
we will
정
listen
판사님께
to
부탁드리겠습니다.
Mrs. Chong.
예, 답변드리겠습니다. 복수 주체에 관한 학설은 굉장히 다양하고
Regarding
이해관한
multiple
대법원 판례가
entities,
확립된
there
것은
are
없는 것으로 보입니다.
No
하지만 하급
Supreme Court
심판결에서
decision in
관련되는
Korea,
몇
but there is
가지
a
사건이 있기
case
때문에
in the
소개해드릴까
lower
합니다.
courts.
첫째로 서울 고등법원은
First, it is a
2004년
case
편의상
decided
사건
by Seoul
판결에서
High Court.
방법
High
발명을
Court.
실제 실시한 행위자가 피고의 의뢰에
It was
따라
held B
피고가
was
원하는 바를
assigned to
위해서
perform the
그
process of
원하는
step
수량만큼
2
제작해서
through
그
4 to
전량을
the process
피고에게
invention
인도한 사안에서
consisting
피고가
of 5
이때
steps.
의뢰받은 자의 실제 행위는 의뢰한 자인 피고의 행위로
So
평가받을 수
B
있다.
produced the
이렇게
desired
판단을
quantity of
하였고,
what A
설사
asked
그렇게 보지
for and
않는다고
delivered the outcome to A
피고의
only.
행위는
And in the view
실제 행위자의 행위를 교사한 것으로서 함께 공동 불법 행위 책임을 부담하여야 한다. 이렇게 판시한 바 있습니다.
of which to perform the above steps according to age request, it should be viewed as such a practice, the patent invention at issue. Another case is also decided by Seoul High Court, and it was held in the case of process invention, which includes multiple sequential steps. It was about telecommunication service. The court said who provided the service and who received the benefits by using the service and who lost profits by losing the service. And the court ruled that the court ruled in favor of the claimed person, and telecommunication provider, service provider, acted only as an agent. And Seoul High Court and Patent Court also ruled in a case regarding medical threat.
다른 주체의 실시를 지배 관리하면서 이로부터 영업상 이익을 향유한 어느 한 단일 주체가
Business or
있는
commercial
경우에
benefits were reaped by only a single entity. The single entity is only liable for the infringement of the patent. If multiple entities were aware and acted on separate steps of the claimed invention, all of them are responsible and all of them are liable for the infringement of the patent. So in summary, it is very important to decide who actually conducted the act. That's all I have.
대단히 고맙습니다.
Thank you very much for the answer.
사례에 대한 질문을 좀 더
Next,
드리긴 해야
let me
되는데요.
ask you
좀더
another
효율적인
question.
진행을 위해서 그리고
For
아마
the
이 자리에
interest of
참여하신
time in
많은
this conference,
분들께서
and
손해액 산정에 대한 부분에
I believe
좀
many
더
people
직접적인
here in this room
관심이
are
있으실 것
deeply
같아서
interested in how to
그들이 좀
calculate
생략을
damages.
하고
So
손해액
I'm going
산정에
to skip some of the
관해서 먼저
questions
말씀을
and jump
진행해 보도록
to
하겠습니다.
questions regarding
지금
damages.
슬라이드에서 보시는 바와
As you can
같이
see on the slide,
국경을 초월하는 특허 침해에서 결국
in cross-border
권리자를
IP
구제하고자
infringement
한다면, 특허
remedies
침해를 인정한다면
for
마지막으로 남는 문제는
IP
손해배상액을 어떻게
right
산정할
holder
것인지 문제이고
to protect them, we have to provide remedy and calculate damage
해외에서의 일실
to
이익을
provide compensations for them.
국내 특허
Here
침해
we may
소송에서
have to
손해배상액을 인정할 수
discuss
있을
the
것인가
lost
이
profit.
부분이 되겠습니다. 이 문제에 대해서
And regarding this
각국의
issue
상황을
and question,
확인해 보도록 하겠습니다.
let's
먼저
hear answers
중국의
from
한
each country. Let me first ask Mr. Han.
예, 답변드리겠습니다. 예, 중국 특허법 제65조의
According to
규정에는
the Article 65 of the Patent Law of China,
규정하고
it
있습니다.
says
예,
as
첫
the
번째 순서는
follows.
권리자가 침해 행위로 인하여 받은 실제
the
손실.
amount of
그다음 두 번째
compensation for
순서는
patent
침해자가 침해
infringement
행위로 인하여 얻은 이익.
and the amount
번째는,
gained by the infringer
특허 실실료,
by the act of
특허
infringement,
실실료
and
넓힙니다.
thirdly,
이 기준에
the
따라서 이 순서에
patent
따라서
license
확정하게 됩니다.
fee
근데
are the three
이러한
criteria
이
to determine
확정이
the
다
amount
불가능할
of damages.
경우에는
If it is difficult
법원에서
to determine
특허권이
the damages
침해
by
행위
using the three
성질이라든가 상황
criteria,
등
we
여러 가지
look
요소를
at the
종합적으로
characteristics of the act of
감안해가지고
infringement and the relevant
인민폐
circumstances,
10,000원 이상,
and
100만 원 이하의 배상을 확정할 수 있습니다.
we can award a
아시다시피
compensation of not
중국이 이제
less than
금방 그 새로운
10,000
특허법을
yuan.
개정하여 명년
China
6월 1일부터 시행되는데요.
will
명년 6월
enforce the
1일부터는
new Patent Act from
판사가 재량권에 의해서
June
판단할
next
수 있는
year.
법정 배상
So from June
금액은
next year, the judge can make discretionary
30,000
decision.
RMB
In that
이상으로부터
case,
500만
the
RMB
amount
이하로
of damages will
대폭적으로
be
증가되었습니다.
compensation
참고하시고요.
will increase from
그다음 권리
30,000
침해자의
yuan to
이익에 관하여 그
50,000
수수행위는
yuan.
이미
And
판매 행위에 흡수되어 있기에
the
그
export
수출이익은
is
실제상에서 판매
export
이익에
includes
포함됩니다.
the gains
따라서 이
from
부분의
selling the goods.
수익은 권리 침해
So the
행위로
gain
인하여
from
얻은
exporting
이익에 산입하여야
infringing
한다고 봅니다.
products should be treated as
권리자의
gains
손실에 관하여
obtained due to
중국 내
infringement.
시장에 한하여 산정하는지 여부에 대해서 현행 중국
Regarding
법률에는
whether only
규정이
the domestic
없으며
market should be considered in
사법
calculating
실무에도 관련
losses
판례가
incurred by the
그
patentee,
원인은
there
예를
has been no
들면
such
특허
case
침해 사건에서
in China.
원고가 주장하는
In the patent
손해배상 금액은
infringement cases, the
통상적으로
damages claimed by the
침해자가 얻은
plaintiff are
또는
generally
법원이
based
재량권에 의해서
on the
판단되는 경우가
gains
대부분이고요.
obtained by
그중에
defendants
절대
or
대부분 거의
statutory
뭐
damages.
95% 이상의
And in
사건에서는
over
법원이
95%
재량권에
of the
의해서
cases,
이것이
the
이
court has
배상금액이
the
판정됩니다.
discretion to
증거가
determine the
부족하기 때문에.
amount of
다른
compensation
한편
due to
중국
lack of evidence.
특허법의 규정에 따르면
And according to
특허권 침해에 대한
article of
배상액은
Chinese
권리자가
Patent
침해
Act,
행위로 인하여 받은 실제 손실에 의해서 확정합니다.
the
따라서
court may calculate the
권리자의
actual losses
손실에는
suffered
계약
by
체결
the
기회를
patentee in
상실함으로
accordance with
인해서
the
초래된
total reduction in
손실을
the patentee's
포함하지 않을
sales.
것으로 저는 보고 있습니다. 그다음 중국 최고법원이 사법 해석에 의하면
And according to the
법원은
Chinese Supreme
특허
Court's
분쟁 사건이
interpretation
심리에
of
있어서
such cases,
권리자가 권리 침해로 인해 초래받은
in
손실을
hearing,
권리자의 특허
in
제품
handling the patent
판매량이
infringement
이러한 침해로
cases,
인해서 감소된 총수량의 특허 제품이
the
한
total
개당
reduction
합리적인 이윤을
in the
곱하여 계산할 수
patentee's
있다 이런
sales due to
사법 해석이
the
있는데
infringement
실무상에서는
can be
이러한
multiplied by a reasonable
상법을 이용해
profit for each
가지고
patented
손해배상금을
product.
계산하는
In
경우는
practice,
거의 없다고 저는 보고
we
있습니다.
don't use the commercial law to
왜냐하면
calculate
증거가 부족하기
the amount
때문에요.
of damages
어떤
because
경우에는
in many
침해를
cases
당해도
where lack of
오히려
evidence,
그
in some
판매량이 증가되는
cases
경우도
of
있거든요.
infringement, the
그다음
amount of sales
권리자의 특허 제품
increase
판매량
a
감소
lot.
총수량을 확정하기 어려울 경우에는
And if it
이
is
역시 사법
difficult to
해석입니다.
determine the
얘기했던 그 사법
total
해석 계속
reduction in the
얘기드리는데요.
patentee's
만약 이런
sales,
판매량 감소 총수량을 확정하기 어려울 경우에는 시장에서 판매된
then
권리 침해 제품이 총수량의
the
특허
amount
제품이
of the total
개당
quantity of the
합리적
infringing
이윤을
products
곱하여
sold in the
산정할 수도
market
있습니다.
can be
약간 뭐
multiplied
이런
by
그
a reasonable
짝퉁이라든가
profit
이런
for each
침해
patented
제품이
product. For example,
어느 정도
if
팔렸다 예를 들면 그
infringing
침해
product like
회사의 그
fake
사이트에
luxurious products,
자기 그 회사의 업적을 자랑하기 위해 가지고
they
우리가
upload the
작년에
amount
어떤
of
제품을
sales
얼마
they
팔았습니다
gained
하고
by selling
사이트에
the
올리면
infringing products
이런
on their
것을
own website,
증거로
bragging
이거
about their
수집해가지고
performance.
이런
So we
계산
can collect
방식으로
such data as
손해배상금을 산정할 수
an
있다는
evidence
것입니다.
and calculate the amount of
이상입니다.
compensation.
중국에
Thank
대한
you.
설명 감사드립니다. 이번에는 미국의
Thank you very
크리스탈
much,
교수님께
Professor
미국에 대한
Krustek.
내용을 답변
Let
부탁드리겠습니다.
me ask you this question.
So this has been an area of active litigation recently in the United States, and the basic answer again has to begin with dividing Section 271F and Section 271A. This is because the Supreme Court in the Western GECO case looked at Section 271F, which involves supplying components of the invention from the U.S., and looked at specifically the question whether lost profits can be obtained for a lost contract abroad. The Supreme Court said that the statute was targeting domestic conduct, even though it's supplying from the U.S. The act of supply still took place in the U.S., and then said that that overcame the presumption of extraterritoriality, particularly because the damages statute, right? The damages statute is focused on full compensation. And so once there's domestic conduct, full compensation, whether it's with lost profits or reasonable royalties for this act of supplying infringing components from the U.S., required that lost contracts overseas would be compensated. So that answer is only a part of the question because in the United States, the basic infringement statute is not 271F, but 271A. So what happens under the basic infringement statute if these contracts are lost overseas or similar circumstances? Before Western GECO, the Federal Circuit held that that's generally not compensable because it's just too remote, and the Federal Circuit even used proximate causation principles and said basically the border cuts off the chain of causation. The Supreme Court left room for proximate cause principles in Western GECO, but it clearly said that the border by itself does not cut off the chain of causation because it allowed recovery of lost profits in that case. So the issue, and I think Judge Jordan will speak to this some more, is whether Western GECO overruled the line of cases that basically said that 271A infringement does not lead to compensable damages for lost profits or reasonable royalties abroad. And so far, the district courts have been pretty unanimous in concluding that it has been overruled, the Federal Circuit line of cases, and both lost profits and reasonable royalties are able to be collected as full compensation for domestic acts of infringement, right? Because the Supreme Court said that damages do not have to really much to do with extraterritoriality. And so one of the cases settled, and another case is currently on appeal. There's actually oral argument in the case last week called SIMO Holdings versus Hong Kong uCloud Link. This case involved basically these day passes, some of which, you take a phone card with you to a foreign country and you load it up and you get more money spent that way. And so that causes further, potentially further compensable actions after the domestic infringement of sort of creating this card in the US. And currently that case will sort of decide how far Western GECO extends, whether it limits itself to 271F or also extends for lost profits and reasonable royalties for basic domestic acts of infringement under Section 271A. We'll find out probably in a few months where the state of the law there is.
네, 감사합니다. 풍부한
Thank you very
정보를
much.
주셔서 대단히
Thank you
고맙습니다.
for
이번에는 독일의
the
상황에 대해서
information.
바흐
Now,
판사님께
let's
부탁드리겠습니다.
turn to Germany. Dr. Bach, Judge Bach.
Thank you. It may start getting a little bit boring, but again, I have to start with the same answer. There is not too many case law on damages in Germany, because in Germany, traditionally, injunctions are more important as a remedy in patent cases than damages. But of course, damages can be calculated as a rule, either based on the infringer's profits or based on a reasonable license fee. There is no case dealing with the problem if the same rules apply in trans-border infringement cases, but I don't see any reason why they should not apply. So I think the main question in Germany is whether or not an act is a direct infringement of the patent, and if so, then the patentee will be entitled to damages, either up to his choice, either based on a license fee or on the infringer's profits, no matter whether it has been a trans-border case or not. I want to repeat one thing which I already mentioned before. Everything I said so far applies to direct infringement. If there is an act of just indirect infringement, then the patentee is not entitled to damages, or to put it more precisely, in the case of indirect infringement, the patentee is entitled to damages only in as far as these acts have led to direct infringement. And so, again, the main question for damages will always be, has there been direct infringement? And if so, the patentee is entitled to damages according to the general principles.
네, 감사합니다. 예, 독일의 상황에 대해서
Thank you very much for the information.
이번에는 이 문제에
Now,
대해서 가장 최근에 그리고 가장 직접적으로
we
실시가
will
이루어진 미국
hear
연방대법원의
about a
웨스턴 게코
case
사건에 대해서
which is
오늘
the
여러 차례
Western Gecko.
나왔습니다만 이 조문이 역의 적용에 관한 사안이 아니라 미국 내에서 실시를 전제하는 271조 A양 사안에도
271A provision. Let's talk about this. The U.S. Supreme Court in Western Gecko LLC versus Ion Geophysical Corporation rule. Let's watch a video.
Now I'm going to answer part 2 with respect to damages. And here's question 3-2. What are the implications of Western Gecko? As you'll recall from the discussion given of extraterritorial infringement, Section 271F of the U.S. Patent Statute makes it an infringing act to export component parts outside the U.S. for the purpose of combining those parts in an infringing way. A couple of years ago, in 2018, in a case called Western Gecko, the U.S. Supreme Court explained that when this type of infringement is found, damages can include foreign lost profits. The Supreme Court overturned the Federal Circuit, which had understood the presumption against extraterritorial enforcement of patent rights to preclude recovering profits for sales as they did not occur in the U.S. The Supreme Court reasoned that the patent statute's focus was still on the domestic conduct that it is regulating, namely the act of shipping out component parts with intent to cause infringement, and that the infringement damages should therefore award complete compensation for that domestic act of infringement, which would include lost international profits, the court said. Western Gecko only mentioned Section 271F infringement and left unstated the impact of foreign sales on other forms of infringement. That issue was subsequently raised in a case called Power Integrations versus Fairchild. Now, that case goes back actually before Western Gecko, although decisions coming out of it come along later. In 2013, the Federal Circuit, now this again is before Western Gecko, which was 2018, the Federal Circuit had not allowed worldwide sales as lost profits for Power Integrations, based on the argument that Fairchild's purely U.S. infringement caused lost sales for Power Integrations both in the U.S. and abroad. Power Integration had argued under a foreseeability basis that they should be entitled to full compensation, but the Federal Circuit had rejected that argument, writing the patent law does not provide compensation for a defendant's foreign exploitation of a patented invention. It ruled that the foreign production, use, or sale is an independent intervening act that under almost all circumstances cuts off the chain of causation for damages purposes. Because that decision predated Western Gecko, when Western Gecko came out in 2018, Power Integrations came to the District of Delaware, the district where I will occasionally sit as a trial judge in patent cases by designation, and they said to the court here that the Federal Circuit's decision in its 2013 case was effectively overruled, and it asked the District of Delaware, which had tried the Power Integrations case before it went to the Federal Circuit on appeal that first time, it asked the District of Delaware to reinstate the jury verdict it had earned here based on international lost profits, on international lost sales. My greatly respected friend, the Chief Judge of the District Court here, Chief Judge Leonard Stark, who I believe many of you at this conference might know, he's spoken at this conference before. Chief Judge Stark agreed with Power Integrations, writing that the Supreme Court's decision implicitly overruled the Federal Circuit's opinion in Power Integrations. Western Gecko had been based on Section 271F infringement, which, as I have said a couple times, involves shipping components overseas to be combined, whereas Power Integrations versus Fairchild was based on Section 271A, which involves just the basic infringement in the United States, infringing acts here in the U.S., but Chief Judge Stark found no justification for distinguishing the two provisions in the context of damages. With an appeal still pending before the Federal Circuit after that decision by Chief Judge Stark, the parties settled their dispute in October of last year, leaving the question unanswered by the Federal Circuit. Western Gecko has only been cited twice by the Federal Circuit and, that I'm aware of, and never in relation to issues of extraterritorial damages, at least thus far. Now, by the time you watch this, a decision may have come out. But as of now, and I'm recording this at the very end of September of 2020, the lower courts have predominantly gone the same route as did Chief Judge Stark in his case here in the District of Delaware. The Eastern District of Texas and the District of Wisconsin have expressly agreed with him. The Southern District of New York has extended the available remedy for worldwide damages to reasonable royalties, which take into account lost international sales. But Judge Mary Ellen Noreika, also a federal judge here in Delaware, found that equitable relief limits to the Western Gecko doctrine do exist. Holding, I think, let me find the name of that case. It's called Abbott Cardiovascular System versus Edward Life Sciences. In that case, she held that an injunction is not an available remedy when the sole purported irreparable harm caused by infringement occurs in another country and the patentee asserts infringement only under Section 271A. The Northern District of California noted that there remains an evidentiary burden to prove the asserting party would have received profits in foreign countries but for infringement. Finally, in another disagreement with Chief Judge Stark's ruling, the Northern District of California found the opposite to what he had found. It said damages cannot be sought for wholly foreign sales under Section 271A, unlike under Section 271F. The judge in that case concluded that it was significant that the Supreme Court had declined to grant certiorari in the 2013 power integrations case, that is, after the Federal Circuit had denied international lost profits. So here was the reasoning in the Northern District of California. The District Court in Delaware had said you could get profits. The Federal Circuit had said you couldn't get those lost foreign profits, and then the Supreme Court declined certiorari. And so the Northern District of California judge said, look, that tells me that Western Gecko is limited to Section 271F because the power integrations case was a 271A case. The Federal Circuit certified an interlocutory appeal from that Northern District of California decision. That happened on January 30 of this year. And so it seems likely that they have an opportunity to resolve that issue of lost profits for foreign sales under Section 271A, and we may hear about that very soon. Indeed, it may have come out by the time you watch this. As you can likely tell from this body of case law and recent activity, the Supreme Court's decision in Western Gecko changed our understanding of damages related to foreign losses for patent infringement. Courts are still working out the contours of this decision, and with the Federal Circuit likely to weigh in soon. But one principle remains consistent, that infringement must remain within or directed at the United States. The change wrought by Western Gecko relates to the scope of the damages calculated as a result of that infringement.
네, 대단히 감사합니다. 조던 판사님의 논평과 설명을 들으셨습니다.
Thank you very much for the
일본에서 있었던
comment.
사안에
Now we will
대해서
turn to
쿠마가이
Japan.
지재고제 판사님께 영상으로
Judge
설명을
Kumagai will tell
듣겠습니다.
us
이번
the
사안은
case
국내에서
via video.
외국의 고객에게 판매하는 행위라는 이 부분에 포착해서 특허 실시 행위로 인정을 한 오사카 지방재판소의 판결들에 대한 구체적 의미 설명입니다.
And an overseas actor. Let's watch the video.
Hello everyone. I'm Kumagai Daisuke, Judge of IP High Court of Japan. It's my pleasure and honor to participate in this event. Okay. Let me start my answer to your questionnaire by briefly explaining Japan's situation of cross-border IP infringement issues. Due to the territoriality principle, under Japanese patent law, generally speaking, the effectiveness of IP rights is limited within the territory of Japan. However, even before 2006 amendment, the traditional prevailing theory has claimed that if a person or entity signs a sales contract with the overseas customers within the territory of Japan, or if a person or entity make an offer for sale to overseas customers within the territory of Japan, these acts would constitute infringement under Japanese Patent Act. So, in the two Osaka District Court decisions mentioned in your questionnaire, the court applied this theory and concluded that selling infringing articles to overseas customers within the territory of Japan is equivalent to the assignment under Article 2, Paragraph 3, Item 1 of Patent Act. And the actions of defendants constitute infringement. In these two cases, the court allowed right holders to be compensated for the profits earned by the overseas sales. Cross-border issue is often relevant to cases discussed under the Indirect Infringement stipulated in the Article 101 of Patent Act. Many Japanese law courts take the view that the production or assignment of components exclusively used to generate infringing goods outside of Japan does not constitute indirect infringement. In other words, to be considered as indirect infringement in Japan, a direct infringement within the territory of Japan should be established as prerequisite. In a decision rendered by the Osaka District Court in 2012, the indirect infringement was discussed. In this case, the defendant argued that his action did not constitute infringement, since he exported components and not the finished products. However, the court dismissed his complaint because the device was temporarily assembled in Japan to test them, and then the defendant dismantled the device before exporting them overseas. The court opined that such action is tantamount to production itself, as stipulated in Article 2, Paragraph 3, Item 1 of the Patent Act. As explained in my draft, the Osaka District Court handled and decided two cross-border related cases by expanding the definition of acts pertaining to infringement. In addition to such interpretation methods adopted by the courts, other various legal theories are proposed to apprehend the cross-border IP infringers who are cleverly trying to evade the patent infringement liability. For example, using various measures such as making the overseas entities conduct the production of the final products. For example, one of the theories states that if the domestic entity has full control over the overseas sub-company, the overseas sub-company's action would be deemed as one with the domestic entity. Therefore, the domestic entity shall bear the consequences or take responsibility for the entire infringement activities conducted by the overseas entity as a part of it. I think in the future case, the Japanese court might use these theories or interpretations to appropriately balance the interests of the right holders and the territoriality principle. That would be all for my answer. I'm looking forward to meeting you tomorrow. Bye.
네, 대단히 고맙습니다.
Thank you very much for the answer.
너무나 아쉽습니다만
I wish we have more
연사분들께서
time
준비해
for this
주신
session.
답변을
Again,
이 정도로 마무리하고 오늘
with that, I'd
세션을
like to conclude
마무리해야
the
될 것
session.
같습니다. 오늘 세션 중에 나온 연사님들의
We
여러
heard a lot of
시사성 있는
insight
답변,
and
그리고 또
very useful
못다나오는 얘기들을
lessons
다음
from
기회에 좀 더
the speakers
자유롭고
and
긴
panelists. If we
시간을
have
토론할 수
more chances in the
있기를
future,
바라면서
why don't
참석해
you
주신
discuss those
연사님들께 깊이
lessons and issues
감사드립니다.
again in the
그리고
future?
현장과 온라인으로
Once again,
참석해
thank
주신
you very much,
여러분께도
the
깊은
panelists, for
감사의
your hard
말씀을
work.
드립니다.
And I would like to also thank all the participants who are here and who participated in the conference virtually. Thank you very much. Thank you very much. This concludes the fourth session. Panelists and moderator, thank you very much. Ladies and gentlemen, please give them a big round of applause.